Chairman, for yielding. I want to make a few remarks on two bills that I've introduced, H.R. 3671 and H.R. 4102. First of all, H.R. 3671 expands the eligibility for a medallion furnished by the Secretary of Veterans Affairs, which would signify that the veteran has veteran status of a deceased individual upon a private headstone or a marker. Currently, VA has the authority to furnish, upon request, a medallion for eligible veterans who died on or after the 1st of November of 1990. H.R. 3671 would remove the date of death limitation by codifying eligibility for the medallion benefit regardless of the veteran's date of death. For nearly 40 years now, VA has administered various programs to provide headstones or marker options for veterans. At times there have been allowances for private headstones, and at times those allowances were not provided for. The programs have evolved over time, and that evolution is somewhat confusing for veterans and their loved ones. Some view the current November 1st, 1990 date as an arbitrary qualification for the medallion. But in fact, this 1990 date was not arbitrary at all. It was delineated as a starting point for the medallion benefits because from November 1st of 1990 through the 1st of September of 2001, VA did not pay a benefit for the purchase of a private headstone or marker for a veteran who were qualified for interment in a national or state veteran cemetery. However, in 2001 through 2006 pilot program, a VA-provided government headstone and marker to eligible veterans regardless of whether or not they had privately purchased a headstone. And in 2007, VA actually made this program permanent. At that time, VA included a medallion as an alternative option, retroactive to the 1st of November of 1990. The medallion has proven to be very much appreciated by veterans and their families, and VA is supportive of the change to allow this option for more veterans. Accordingly, I'd like to encourage all of you to support the broadened eligibility that is contained within H.R. 3671. And then additionally, I want to highlight to your attention H.R. 4102, which I've introduced along with Representative Wolarski, to clarify that the estate of a deceased veteran may receive certain accrued benefits upon the death of the veteran and for other purposes. This bill corrects a grave injustice that has resulted from the tremendous backlogs existing within the Veterans Benefits Administration and will prevent the occurrence of future incidents. The fact is that unacceptable wait times at the VBA regional offices have contributed to tens of thousands of veterans dying before their benefits are granted. While VBA currently reports an average days to complete figure of 285 days, I recall that we are not long removed from the agency's 2-year-old claims initiative, which focused on rating claims that have been pending for over 700 days. And as to appealed claims, while the Board of Veterans Appeals Chairman's report for fiscal year 2013 has not yet been approved or provided to Congress, we can anticipate a grim account as veterans' appeals continue to rise unresolved for 3, 4, or more years. Now, under current law, only a veteran's spouse or children under the age of 18 and dependent parents are eligible to receive accrued disability benefits in the death of a veteran's claimant's death. H.R. 4102 would provide another option for payment into the veteran's estate. To demonstrate the need for this bill, I highlight the experience of Indianapolis veteran Shelton Hickerson and his daughter Sharon Hickerson Thurman. In 2000, Mr. Hickerson filed a claim for disability benefits. VA denied the claim, and Mr. Hickerson's appellate process began. Ultimately, on June 27, 2013, after more than 10 years, VA awarded Mr. Hickerson a 100% disability rating with retroactive pay in excess of $375,000. But sadly, Mr. Hickerson passed away the same day as the payment of the benefit. Mr. Hickerson was entitled to this compensation, and had he lived just one day longer, he would have been able to deposit that accrued benefit properly into his account. However, he did not, and his daughter was not eligible to receive the accrued benefit because she was no longer a dependent. VA's errant and dilatory processing of Mr. Hickerson's claim resulted in no benefit to Mr. Hickerson, to his estate, and therefore his family received nothing. There's no doubt in my mind that VA will make mistakes in its claims rating process. However, the party to the transaction that pays a price for these mistakes should not be the veteran or the families of those lives who are also affected by illness or injury caused by their service. So I want to encourage all of you to support H.R. 4102, a bill to clarify the estate of deceased veterans may receive accrued benefits upon the death of the veteran and to provide relief in the case of Mr. Shelton Hickerson. Mr. Chairman, thank you for your time. I yield back.
Thank you, Chairman.